Hey there, guys. I'm happy to be with you again today, and I'm excited to carry on our conversation about judicial power and the establishment of civil liberties and civil rights in contemporary American politics. I believe that this is a uniquely relevant topic to consider today because so often the political questions in our nation go to the judiciary, and the decisions the judiciary makes often have a great deal to do with how we ourselves conceive of civil liberties and civil rights. Some of the most important establishing moments in the history of various civil liberties and civil rights in America did not come about because of congressional action, but rather because of the Supreme Court's activity and the role that the court has played, especially in the history of America following the 1940s, roughly. So thank you all. I'm, again, just excited to carry on this discussion, but just a couple of procedural remarks. Of course, your final projects are coming up, so do remember to take care of that this week. Your presentation will be due by the end of the week, and be thinking about the best way of getting your paper going. That way you don't wait until the last minute in week 10 to take care of it. The paper and the presentation should ideally complement each other, and I think that today's unit will go a long ways towards helping you better understand the role of the judiciary and also come to a deeper knowledge of the case that you will be studying outside of today's lecture. So today's lecture will focus on the topics of civil liberties and civil rights by first clarifying certain things about the Bill of Rights, going into the modern interpretation of the Bill of Rights using the 14th Amendment, and then shortly after, we will be exploring the various cases, most of which have been assigned to you this week, and we will be trying to understand how these cases fit into these judicial and legal doctrines that we will be exploring today. So before we do anything else, as I always like to do, I'd like to begin with a brief review. In our lecture last week, we considered the structure and the philosophy of the American judiciary. We're so accustomed, I think, to seeing the Supreme Court and appreciating or deploring its rulings that in some ways I think we take for granted the existence of the court. In many respects, the Supreme Court's power is very unusual when it's compared to judicial systems in other places. In many other nations, such as Great Britain, they do have a Supreme Court, so make no mistake. Any developed country that has a serious tradition of the rule of law is going to need courts to adjudicate those laws. So we're not unique because we have a court, but we are unique because of the power of the court. In Britain, for example, the legislature is supreme. And if court decisions fly in the face of the legislature simply overrules the court. But in America, that is not the case. The court's use of the doctrine of judicial review to declare laws passed by Congress unconstitutional gives it a status that is nearly equal to the Congress, if not, in fact, equal to the Congress. And so the court is very powerful by the standards of other nations. But even by the standards of the American political system specifically, the court's power today is quite strange when you compare it to the early republic, for example. In the early republic, the Supreme Court was a pretty weak institution. In fact, you may be surprised to learn this, but the Supreme Court didn't even have its own building until the 1940s. For most of our history, it was housed in the basement of Congress. I am actually of the belief that if we want to get these justices to behave themselves, maybe we need to tear down that big building, that big fancy building they have and stuff them in the basement of Congress again. Maybe that'll get them to know their place and stop usurping power that they don't legitimately have. So that fact notwithstanding, the very fact that the court didn't have its own building says something to us about which of the institutions the founders thought would be primary. And they certainly thought the court would not be primary, whether Federalist or Anti-Federalist. That was not, no one wanted to see the judiciary be the most powerful of our institutions. And so this is interesting because, as we looked at last week, many of the Anti-Federalists were very fearful of the design for the new judiciary in the Constitution. Anti-Federalists feared that we would have an out-of-control judiciary where irresponsible judges would basically tear up the Constitution and do whatever they want with very little to restrain them. And while this is arguably a good picture of what the court is like now, we ought not to believe that this explains and characterizes the court for most of American history. As I have just said, the court was actually noticeably quite weak for most of our history. John Marshall, in his famous Marbury versus Madison decision, certainly established the doctrine of judicial review. But it is less well known that he actually refrained from politicizing the judiciary and upheld an early understanding of judicial restraint. So the facts of the Marbury case, which is so important, the Marbury case that establishes judicial review, this important case, the facts are actually somewhat convoluted, and I don't think I have time to get into them. But I can leave you just with the fact that Marshall's decision actually helped the rival political party. It helped Jefferson and Madison in the short term, and it hurt Marshall's own Federalist Party. So it can hardly be called an example of judicial activism or the court legislating from the bench, right? Marshall empowered the court in the long term because he establishes judicial review as a legitimate principle under our constitutional system. But the actual decision that he made was in some ways against what the ruling Federalists would have liked for him to have done. Alexander Hamilton, whose argument for judicial review we considered last week, you may remember that Hamilton said the judiciary was supposed to be the least dangerous of all the branches because it lacked both a sword and the purse. So it did not have the enforcement mechanism that the executive does, and it doesn't have the power of the purse that the legislature does. So how can the court really alter the nation's policies that considerably? And so one reason for the limited nature of the judiciary in the early republic is that judicial review was widely distinguished from the idea of judicial supremacy. As we discussed last week, judicial review is perfectly compatible with the doctrine of checks and balances. However, judicial supremacy is not. As we considered last week, judicial supremacy, the idea that the court alone has the authority to interpret the Constitution. This doctrine, in effect, makes the court the arbiter of its own powers and puts the other branches into a complete subordination to them. And so this doctrine, it is very different from the basic idea of judicial review. And I want us to understand that because it's very important for making sense of how the court has, in effect, taken on such important powers in creating civil liberties over the years. So, just by way of a beginning, today we're going to try and understand how and why the court has become so much more powerful. In modern times, the judiciary no longer really focuses on checking the powers of the Congress or the president, which is what it did in the early republic. In the early republic, the primary focus of the court was on defending property rights against violations by the Congress or by the presidency. But in modern times, the judiciary is, in many respects, shifted to a focus on civil liberties, maximizing the amount of liberties that individuals enjoy under the Constitution. And in order to do this, it's worth pointing out that the Supreme Court often restricts the powers of the state governments rather than the federal government. Certainly there are some civil liberties cases where the federal government is restricted, but in modern times, the vast majority of civil liberty cases actually impose restrictions on the states. And so judicial review has in effect become a limitation not only on the federal government, as it was supposed to be, but has instead become a check against the states in a way that the court can nationalize political issues. We're going to consider that, troublingly, the court sometimes even tries to create and enforce rights that are not actually in the Constitution. So it sometimes restricts the power of the states in the name of individual rights, but these rights were never actually provided for in the Constitution, which means that there was never any process by which the consent of the American people figured into the creation of these rights. And so this new system where the court sometimes invents new rights and liberties and in effect changes political policy for the American people, this system has sometimes been called government by the judiciary. Many critics wonder if this is in fact a kind of lawless usurpation of power by the Supreme Court. So, to begin, it's worth considering the basic question, what are civil liberties? And this question is sometimes deceptively simple. Many people actually use this term, but don't really know precisely what civil liberties are. And so, if we're going to see how the Supreme Court has taken on this new role in defining, limiting, and clarifying the nature of civil liberties in our republic, we have to understand what it actually means to speak of civil liberties. So civil liberties at their most basic level are simply the rights that individuals enjoy against their government. So if the government is restricted from doing something, if it can't get in your way of and prevent you from speaking your mind or writing something, then this is a civil liberty that is reserved to you under your constitutional system. So these kinds of liberties are liberties that are in effect protected by the government not acting, as paradoxical as that sounds. You have the freedom of speech, for example, because you can speak your mind without fearing that the government is going to shut you down. You have the freedom of the press because you can write in your local newspaper and not fear that if some politician sees what you said about them, you could face jail time, and so on and so forth. And so these liberties are very different than the positive liberties that some philosophers talk about, where, for example, if you have a positive liberty to health care, then that means government gives you this, and that's how your liberty is protected. Government gives you free health care, and that's your liberty being protected. These liberties are very different because these are liberties that are basically they basically require the government to not do something, to not restrict your freedom of speech. And so that's what civil liberties are. Sometimes we use the term civil liberties interchangeably with the term civil rights, but this is not technically correct. The term civil liberties is usually used in reference to individual freedoms against the government. And so these are liberties that are usually applicable irrespective of whatever your ethnic or gender or sexual orientation is. And so whatever your ethnic background, gender, or sexual orientation, these are liberties that you enjoy as a citizen. And so we don't really think of civil liberties in the racialized way that we often do civil rights. Civil rights is more frequently thought of in connection with the rights of minorities to be able to participate equally with majorities. And so especially racial minorities figure prominently in these civil rights considerations. That said, the terms are related enough that I think we can talk about both today. So we're going to focus primarily on civil liberties, but there will be some discussion of civil rights too. Now, one very important concept that you've got to understand in order to understand why civil liberties can be such a sticky concept is that it's very easy to speak of civil liberties and things like freedom of speech, freedom of religion, freedom of the press, in a kind of absolute way that makes it sound like these are easy to articulate, easy to define, and easy to defend. But actually, civil liberties can be a little messy. And this is because civil liberties sometimes, so the civil liberties asserted by one person sometimes conflict with civil liberties asserted by another person. The Supreme Court has often had this persistent problem of having these cases come before it where someone's freedom of speech, for example, conflicts with someone else's freedom of assembly. Well, what do you do with this? Which liberty matters more? I mean, they both matter, so how do you decide in these cases and controversies, to use our constitutional language, which one matters more? So this is the problem of rights in conflict, when the individual rights of one person conflict with the individual rights of another. So to clarify what I mean here, let's take just this famous recent controversy here in Lakewood, Colorado, the Masterpiece Cake Shop. Some of you are familiar with this because this is the controversy involving the Christian bakery that denied service to a gay couple, and it goes before the Supreme Court. Well, this case goes before the Supreme Court because it's a great illustration of this problem of rights in conflict. So, the Masterpiece Cake Shop in Lakewood, Colorado, where I live. It's a shop owned by religious Christians who believe that homosexuality is a sin, so they're freely associating with one another, and they are making this business as a business that they want to have Christian principles, so that's their freedom of religion at work. Well, a gay couple goes to this shop and they request that this Christian bakery make them a wedding cake. The Christians who own this bakery say, we're happy to bake any other kind of cake for you, but we don't want to participate in a wedding by baking a wedding cake that we believe is a sin against God. Well, this means that the gay couple can claim that they're being discriminated against because they're having service refused to them, and they supposedly have this right to participate in commerce on an equal footing with heterosexual couples in the context of a Christian bakery. And so these are two different rights in conflict here. The right of the Christian business owners to practice their religion freely and to associate with fellow believers, as well as the right of a gay couple to participate in commerce without discrimination. Unfortunately, when this went to the Supreme Court in 2018, the court kind of dodged the question. They basically said that the state government of Colorado did impose unjust, they unjustly censored the Christian couple by condemning their religious beliefs. But the court basically ignored the question of whether religious belief and religious freedom can justify allowing a Christian business to deny service to gay people. So I would expect that this will go to the court again one day, because this important issue in religious freedom, it's going to be a matter that has to have a resolution. But in any case, this is a great example of rights in conflict. We often associate civil liberties with the Bill of Rights, and especially with the First Amendment. You often will assert your First Amendment freedoms, right? So your basic freedoms of speech, religion, the press, petition, free assembly. And so the First Amendment is kind of the backbone of what we understand to be modern civil liberties. But there are other very important provisions of the Bill of Rights, too, that also have much to say about the civil liberties that we as citizens enjoy. The Second Amendment, for example, provides for a right to bear arms, and this is a right that is valued by many American people, and especially by conservatives, who I would imagine many conservatives might say that's their favorite part of the Constitution, right? The right to bear arms. So carrying on, just listing out the Bill of Rights for ease of reference here. The Third Amendment. Not a lot of Supreme Court cases about this because it's fairly straightforward. The government cannot mandate that you quarter troops in your home. This is something the British often did before and during the American Revolution, and the Americans have always hated it. So the government can't just require that you house troops, right, and basically have to live with that fear. So let's move on. Fourth, Fifth, Sixth, Seventh, and Eighth Amendments. These are amendments that are very important in criminal justice issues and in cases involving the rights of the accused. So we're going to see some cases that we're going to explore involve one or all of these amendments. The Fourth Amendment protects you against unreasonable searches and seizures. The Fifth Amendment guarantees that you cannot have any confession tortured out of you. So involuntary or coerced confessions is the Fifth Amendment. The Sixth Amendment, meanwhile, protects your right to a speedy and fair trial by a jury of your peers. The Seventh Amendment is the jury of your peers. Sixth Amendment, speedy and fair trial. And then the Eighth Amendment is a restriction on the government from imposing excessive bail or imposing cruel and unusual punishments. It's worth mentioning that all of these different rights in the Bill of Rights, so First Amendment all the way up until the Eighth Amendment, these are traditional English common law rights. These were not newfangled things to the founding generation. But they had a very firm and concrete kind of basis in English legal precedent and in English principles of liberty. And so in many respects, these liberties that should be uncontroversial have become controversial by way of Supreme Court interpretation. We're going to see how throughout the 20th century, the court sometimes began to interpret these amendments in somewhat loose ways that often just met with a lot of controversy over whether it was distorting the Bill of Rights and distorting the Constitution for the sake of arriving at some sort of policy perspective that it wanted to see affirmed. So another point about the Bill of Rights that we have to understand as a foundation. These liberties that I just listed, they all were meant to protect individual liberty against arbitrary government. But this is critical here. You have to understand this. But the Bill of Rights was originally intended to be a states' rights instrument. So the arbitrary government that was being restricted here, it was not the state governments, it was the federal government. This is clear both from the wording of the Bill of Rights itself as well as from the explicit language of the Ninth and Tenth Amendments. So if you read the Bill of Rights, the First Amendment, what does it say? Well, it says Congress shall pass no law respecting the establishment of religion or restricting the freedom of speech, so on and so forth. So who is the one restricted? Well, it's the Congress. It's the legislative body of the federal government, and by extension, the executive branch that enforces these federal laws. And so the Bill of Rights' explicit language imposes rules and restrictions on the Congress. In the early years, it had nothing to do with restricting the state governments from doing things. So let's consider the Ninth Amendment. So the Ninth Amendment, which says that the enumeration of certain rights shall not be construed to deny the existence of other rights held by the people. So why do we have this Ninth Amendment here? Well, the Ninth Amendment was meant to address an important theoretical issue that's posed by the inclusion of a Bill of Rights. This was a problem that worried many of the Founding Fathers. Many, especially the Federalists, worried that if we have a list of rights at the end of the Constitution, we may come to assume that the government can do anything that isn't listed. So this is important here. So Alexander Hamilton in Federalist number 84, he says that the Bill of Rights is not only unnecessary, it's also dangerous. Because if you have this list of rights at the end of the Constitution, it's going to be subtly importing a foreign and monarchical idea into the Constitution, namely that the government is sovereign and simply gives rights to the people as a gift, reserving all other rights unto itself. But in a republic, the people are sovereign, not the government. And we're supposed to assume that the people are the ultimate authors of legitimate political authority. So just understanding this example again, to sort of highlight using an illustration. Hamilton and the other founders, they're worried that, okay, so we have a Bill of Rights. Let's say we have a Bill of Rights and it includes the freedom of speech, the freedom of religion, the freedom of the press. But what about the rights that we left out? What about something trivial like your right to go fishing? We can't possibly list out all of the little rights that people have, and in a republic, we assume the people the people are assumed to have the sovereignty and give powers to the government to do a few things, but reserve all other rights to themselves. So we might forget to list out trivial little rights like the right to go fishing. And we might even forget to include fundamental rights like the right to get married and have children and start a family. And so Hamilton is worried that, hey, now, this Bill of Rights, it could be twisted to give people the impression that, hey, if it's not in the Bill of Rights, the government can do these things. So the government might turn to the Bill of Rights and say, well, we can't restrict your freedom of religion, we can't restrict your free speech, but you forgot to say something about the right to get married. And so that's the conundrum that the founders are worried about. They're worried that this Bill of Rights, this list of thou shalt nots in the Constitution, it might be interpreted in such a way that the government is assumed to have all the power and just gives a few rights to the people as a gift, as a kind of concession to them, but reserves all other power to itself. And so the founders want to avoid a situation where the people assume that if it's not in the Bill of Rights, then the government can do it. And so that's the reason we have a Ninth Amendment, which says, again, the enumeration of certain rights shall not be construed to deny the people of other rights that are not enumerated. So just because we didn't list your right to get married or your right to go fishing, that doesn't mean that it's not a right that's legitimately reserved to you. And in general, the founders, they trusted the state governments to do the brunt work of protecting these individual rights. Most states had their own state bills of rights. And to the founders, it was important to protect the political authority of the states to define and clarify rights as they saw fit without the federal government getting in their way. And this is where the 10th Amendment comes in, the companion to the 9th Amendment. The 10th Amendment is the clearest statement of states' rights in the whole Constitution. It clarifies that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. And so this Constitution is a constitution based on the principle of enumerated powers. The federal government is not assumed to have the power to do anything at once, contrary to what many Americans today might believe. No, the doctrine of enumerated powers means that the people of the states in these sacred ratifying conventions have delegated to the federal government certain powers and certain tasks that they believe their state governments are not up to the task of doing. So, foreign policy, interstate commerce, these kinds of things that are in Article 1 of the Constitution. These are powers that the people of the states have delegated to the federal government. And the assumption is that the federal government can do only those things that are in the Constitution. It can't go outside of the Constitution, but it has enumerated powers that it can do, and anything else is left to the people of the states. And so the 10th Amendment is a states' rights amendment. It clarifies that the states came before the federal union, and the sovereignty of the states ought to be respected as much as possible. So this is a clear statement of enumerated powers and of the fact that the federal government is not supposed to do anything at once. And so it's important to give this kind of holistic and comprehensive view of the Bill of Rights and what it does, because I think so often the Bill of Rights is so deeply misunderstood. So many Americans today, I think, regrettably see the Bill of Rights as the only part of the Constitution that's worth celebrating. And this is in many ways quite ironic, actually, because most of the framers of the Constitution, which includes people who matter a lot, like George Washington, Alexander Hamilton, and in the initial stretch, James Madison. So the fathers of our Constitution, they actually opposed the idea of a Bill of Rights. Not only did they oppose it, but they also thought it was dangerous and was based on faulty principles. And so many Americans today, when Constitution Day comes along in September, they might say something like, oh, I love the Constitution because it gives me freedom of speech, or it gives me the right to bear arms. But notice what most Americans don't say when Constitution Day comes along and they have to celebrate the Constitution. Most Americans don't say anything about things like federalism, the reserved powers of the states under the Constitution. Most Americans don't mention the separation of powers, which carefully divides power between three branches and prevents any one single branch from amassing too much concentrated power. And they don't say anything about the bicameral structure of the Congress, which ensures that you'll have a House of Representatives that is more directly democratic and more attuned to the immediate wishes of the people, and a Senate which is much more deliberative and much more oriented to protecting the powers and authority of the states. And so, in effect, Constitution Day comes along in September, and most Americans don't celebrate the Constitution at all. They celebrate the Bill of Rights, which was attached to the Constitution in the after years, as a way of placating the anti-federalists who were opponents of the Constitution. And so I can't emphasize this enough, that at the Constitutional Convention, there were actually only a few individuals who supported the inclusion of a Bill of Rights. So you have someone like George Mason of Virginia, who thought it was a good idea. He's even considered the father of the Bill of Rights. But nonetheless, at the Constitutional Convention, every single state delegation, so all 13 state delegations, voted against the inclusion of a Bill of Rights. And so I say this not to criticize the Bill of Rights or to criticize Americans who value the Bill of Rights, but simply to clear up a misconception. I think many Americans think that the only part of the Constitution that matters is the Bill of Rights. And they even may think that what makes the Constitution great is simply a list of rights at the end. But to the founders, what made the Constitution great was the meticulous structure of government that they created. The purpose of the Constitution was not to list rights and to explain what the people can do. The purpose of the Constitution was to establish a limited government based on enumerated powers. And so the founders regarded the Bill of Rights as unnecessary and dangerous, as Federalist 84 memorably puts it. So why would the Bill of Rights be unnecessary, according to Hamilton? Well, it's unnecessary because, as the Federalists understood it, the liberties of the people were already protected by the Constitution's careful arrangements, like the separation of powers, bicameralism, and federalism. And so someone like Madison might say, if you want to protect religious liberty, what you need is not really some right attached to the end of the Constitution that says you have religious liberty, because those are just empty words, right? But rather what you need is a structure that forces this extended republic that Madison had talked about in Federalist 10. And what does the extended republic do? Well, it ensures that you're going to have a Congress full of representatives whose districts comprise tons of different religious sects. And so you're going to have Anglican representatives. You're going to have Congregationalist representatives. You're going to have Presbyterian representatives, and so on and so forth, and even some Catholic representatives. And so the point here is that what really protects religious liberty is this structure of the Constitution that ensures that no legislation can pass unless it has a very broad base of support with the American people, irrespective of religious belief. So you're not likely to have any laws violating religious liberty passed by a Congress that comprises such a vast number of representatives coming from different walks of life. And so what protects the liberties of the people is the structure of the Constitution itself, not just a list of rights at the end of the document. But the Federalists went further than just saying it's unnecessary. In fact, they said it's dangerous. And this is because of what I said already about the Ninth Amendment. The Bill of Rights could be interpreted in such a way that it suggests that ultimately the government is sovereign, not the American people. If you think about it, bills of rights, they originated in monarchies, like Britain. The monarch would give to the people a few rights that he wouldn't touch. And the assumption was that he could do anything else. And the founders say, well, we don't want anyone to believe that in America. We don't want people to think that the government is in charge rather than the American people. And so this was the problem with the Bill of Rights. So why did the founders actually come to support it? Well, the Federalists ultimately agreed to support the Bill of Rights because they saw it as a way to broaden the consensus of support for the new Constitution. So James Madison, he famously changes his mind on this question. And one of the main reasons was that many of the founders thought that, hey, many anti-federalists are worried about this new Constitution. They don't like it very much. And one of the main reasons is because it lacks a Bill of Rights. And so maybe we ought to include a Bill of Rights just to broaden the support for the new Constitution with the American people and make sure that more and more Americans find it to be a good document. However, so the Bill of Rights can be included in that way, but that doesn't necessarily resolve that problem of the endangerment of certain rights by virtue of the fact that you might be suggesting the government can do anything else that's not listed in the Bill of Rights. And so they had to resolve that problem, and they did that with the Ninth Amendment. The Ninth Amendment was meant to resolve this issue. And so whether the Bill of Rights was a good idea or not, it has nonetheless played a very important role in modern times, especially because of its interpretation by the Supreme Court. Over the years, the court has shifted away from the things it did in the early republic. In much of American history, the Supreme Court generally focused on protecting property rights against violation. And they generally protected the property rights of citizens from violation by the federal Congress, especially, and by the presidency. And so the court generally tried to promote limited government. But in modern times, the court has shifted its focus to protecting individual civil liberties against violation by the states. And this has given the court new opportunities for judicial activism. It uses the Bill of Rights as a weapon against the states. And this has basically turned the Bill of Rights completely on its head from its original purpose. Anti-Federalists saw the Bill of Rights as an instrument that was meant to protect the rights of the states against the federal government. as we saw last week, they were opponents of the judiciary and worried about an out-of-control group of judges. But today, the judges use the Bill of Rights to impose new limits on the states. And sometimes these judges actually create rights that are nowhere in the text of the Constitution, which is another way of saying, frankly, that the court has become the author of its own powers, and it no longer believes itself to be bound by the enumerated powers of the Constitution. So we need to consider, how did this happen? What are examples of this tendency in modern times? And I want us to better understand these things over the course of this lecture. So the first thing to understand that's really important is that the constitutional justification for the federal interference in internal state affairs to protect civil liberties, the constitutional justification for this is not actually within the Constitution, not actually within the original Constitution. And it's not actually even within the original text of the Bill of Rights. As I mentioned, the text of the Bill of Rights imposes limits on the Congress, not on the federal government. It imposes limits on the federal Congress, not on the state governments. So how did we get to the point where the Supreme Court often interprets the Bill of Rights as something that binds the states? Well, it comes from the 14th Amendment. This is why it was seen as perfectly fine for the state governments in the early republic to have established religions, which, for example, would use taxpayer money to fund specific churches that the majority in the states liked. Many Americans thought this was perfectly fine, even if some others opposed the practice. But no one regarded it as unconstitutional if a state wanted to fund a church, for example. But today, this would be considered unconstitutional by the modern Supreme Court. So the reason for this change is not because the First Amendment, because the text of the First Amendment has changed. No, the reason for this change is because of the 14th Amendment and the doctrine of incorporation that the Supreme Court utilizes in the wake of the 14th Amendment. Many scholars regard the 14th Amendment as tantamount to a new constitution, and that's something that is somewhat disturbing to think about, right? We often talk about the Constitution of the Founders, and yet so much of what the Supreme Court does is justified by reference to an amendment passed after the founding. So I want to look at this and understand how this took place. So the 14th Amendment passed in the wake of the Civil War. So it was seen as a way to protect the due process rights of the newly freed slaves. You have to put yourself in the shoes of the people at the time of the 14th Amendment in 1868. You've gotten rid of slavery with the 13th Amendment. Slavery is banned. It's illegal. But that doesn't necessarily settle the political question of what do you do with the freemen. Do you make them citizens? Do you not make them citizens? Do you send them somewhere else? Do you let them live in America? What do you do? Well, the answer of the authors of the 14th Amendment was we ought to make the free blacks citizens, and we ought to provide them with the same equality under the law that white citizens enjoy. And so their idea was that whether you're white or black, whether you were the son of a slave or even a former slave yourself, or whether you were a white person, you should have the same right to a trial by a jury of your peers, for example, that any other person does. And so that was the purpose of the 14th Amendment. It was meant to provide for the due process rights of the newly freed slaves in the aftermath of the Civil War. So a very noble purpose, a purpose that is perfectly understandable given the historical context. But we have to look at what the effect of this amendment has been and how the court has in some ways arguably perverted it from its original purpose. So here's the key text. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So I often have one of my students in my classes read this sentence and try to pinpoint anything about it that seems strange. Is there anything about this that could be used to justify, for example, gay marriage as a national right, or abortion on demand as a national right under the Constitution, or the stripping out of all prayer in schools, or the ban on states restricting particularly virulent forms of pornography? So I ask them that because that's what this text has been used to do. So this line here, seemingly innocuous, seemingly inconspicuous, it has been used to nationalize abortion rights. It has been used to impose gay marriage on the nation. It has been used to ban state censorship of pornography. So things that literally have nothing to do with the rights of the newly freed slaves, or even with racial equality in general. So how did this happen? Where is the justification for this? So here's what happened. In this phrase, any state, nor shall any state deprive any person of life, liberty, or property without due process of law, there is something explosive that is easy to miss. In the Fifth Amendment, there's the similar phrase that no person can be deprived of life, liberty, or property without due process of law. But notice who the entity is here that is restricted. In the Fifth Amendment, it's the federal Congress. But in the 14th Amendment, it's the state. It's the states. So no state can deprive another person of life, liberty, or property without due process of law. So this is the first thing in the Constitution that gives the federal government a power to basically interfere in the internal affairs of the states and supervise the states and make sure that they're doing the right thing. And so if this text had been interpreted narrowly to be understood as the actual due process rights of newly freed slaves, so if this text had been interpreted in such a way that white people and black people, regardless of the state they lived in, could not be thrown in jail arbitrarily, they would all have a jury trial, they would all have the right procedures utilized on their behalf to ensure fair treatment under the law. If that kind of due process had prevailed, then you still don't get the kind of wonky interpretations of the 14th Amendment that lead the court to strip prayer from schools and these kinds of things, or to require that all states permit abortion up until the third trimester, as Roe did. And so basically the court was only able to do that by incorporating rights against the states. So this is the key thing that happened. The 14th Amendment is used by the Supreme Court as a way to take the Bill of Rights and basically say that this Bill of Rights, which was originally meant to restrict the Congress, now restricts the state governments. Why? Well, because no state can deprive you of liberty under this clause. What is liberty? Well, we are going to define liberty as the First Amendment of the Bill of Rights, or the Second Amendment of the Bill of Rights. And so basically the court uses this phrase of life, liberty, and property without due process, and they import into it the freedoms of the Bill of Rights and use that to say, well, the states can't restrict these freedoms either. And we're going to interpret these freedoms in such a way that we impose a lot of shackles on the states and what they can or cannot do. We're going to see examples of this in some of the cases we're going to look at. And so basically, this is what's known So incorporation, again, just because it's so important and we got to understand it. The court is incorporating the Bill of Rights against the states. It's no longer using the Bill of Rights simply as a restriction on the federal government, but it's using it to restrict the states. Where this gets even messier is where the Supreme Court doesn't even always incorporate rights that are in the Bill of Rights against the states. Sometimes the Supreme Court will simply invent rights and basically pull them out of thin air and say, well, states have to protect it because we think it's a right that we ought to have under the Liberty Clause. And so that's substantive due process. That's defining due process substantively by trying to basically import something in the word liberty that the judge thinks is a good policy. So abortion is a good example of this. Even if you were incorporating the Bill of Rights and you believe that was legitimate, which reasonable people can think that, abortion is not in the Bill of Rights. And so substantive due process, this idea that you can interpret the word liberty substantively and basically out of thin air say, well, abortion rights is a liberty that people ought to enjoy in all the states, and so we're going to nationalize it. So this is what's happened. This is why the Bill of Rights seems to have very little to do with the Bill of Rights of the early republic. And so this is fundamental as we try to understand civil liberties. The important thing for our purpose here is that what this has done, in effect, has meant that due process no longer really imposes limitations on the government. It no longer is about guaranteeing the proper legal procedures to ensure that citizens are not deprived of life, liberty, or property without legitimate application of the rule of law. But rather this substantive due process doctrine and this incorporation doctrine, these have been used to give the court this nearly unlimited power to simply define liberty and to impose new restrictions on the states that many Americans disagree with. And so it's been an instrument that has arguably been, in my more negative moments, I would say it's an instrument of tyranny, where the Supreme Court seizes from the American people the ability to make decisions about self-government on the grounds that the judges know better than we do. So let's look at some actual examples of this before we conclude for today. So one of your assigned cases was at Engel versus Vitale. This was not actually the first Supreme Court case dealing with the issue of religious freedom. There were several cases before this, notably the Everson versus Board of Education case. The Everson Board of Education case is the one that coins the phrase, the separation of church and state. And it is the one that is an important contextual backdrop for the Engel case, because in the Everson case, this was where the court, for the very first time, incorporated the First Amendment's religious establishment clause against the states. So remember, in the early republic, state governments often had established churches. State governments protected religion as they saw fit. Some had complete religious freedom. Others had established churches. But in general, it was seen as a state's authority to decide on religious policy for itself. Well, what the Everson case did was it took the 14th Amendment and said, well, under the Due Process Clause, religious freedom is a fundamental liberty. And the separation of church and state is the meaning of religious freedom. And so you cannot have any state sponsorship of sort of private religious schools. The facts of this case are interesting, and I would like to talk about them, but we don't have time to talk about this one, and it wasn't assigned. So I'm going to move to the Engel case. But the important outcome of the Everson case was that it basically codified this idea that the separation of church and state is a fundamental principle of the Constitution, even though that phrase is not in the Constitution. Students of history know that the phrase the separation of church and state, it comes from Thomas Jefferson. It did not come from the text of the Constitution itself. In fact, there's a lot of problems, I think, with relying on Jefferson's opinion about what the First Amendment meant, because Jefferson was never at the Constitutional Convention, and his religious views were very heterodox. He wrote his own Bible. He was not a friend to Christianity. He actually disliked Christianity. And his views on a very strict wall of separation of church and state were rejected by other founders, even those who were pretty important, like George Washington and John Adams. And so, all that said, the court has nonetheless declared that because Jefferson thought the First Amendment meant separation of church and state, that's what the First Amendment means, and states have to respect it. So that's the context of this Ingle versus Vitale case. Ingle versus Vitale had to do with the issue of school prayer. Does school prayer constitute an unjust violation of this separation of church and state principle? So there's a few important facts to consider here as we look at this case. The first thing that's of note here is that the prayer in question, so the prayer that the intercom or that the teachers led the students in the morning, this was not a particularly Christian prayer. So it was a prayer that never mentioned Jesus. It never affirmed the divinity of Christ. And it was a prayer that whether you were a Jew or a Christian or a Muslim or even just a non-Christian theist of any kind, you would be okay with it, because it just appealed to a sort of vague God that is asked by the praying teachers to watch over the students and help them learn and help them have a good day. So this is a very simple prayer, and it's not one that is particularly meaty in its theological substance. Additionally, if that kind of blatant non-sectarianism was not enough, there were exceptions granted to those who dissented from the act of prayer. So the people who administered this school knew that there were some people that were atheists, some people that rejected prayer altogether and might not want to be a part of it. Well, they were perfectly allowed to refuse to pray, refuse to bow their heads, or step out of the room. And so what's the problem here? Reasonable people might ask, why even sue over this? But the concern of some militant atheist type groups would be, that imposes a kind of pressure on them to conform to the religious beliefs of the majority, and their individual right to be an atheist should be equally valued as any right to believe in prayer. And so this case goes to the Supreme Court in the Ingle versus Vitale case, and it has to decide, does this prayer in school constitute an unjust violation of the separation of church and state? Even though there's all these ways that the administrators tried to make it perfectly fair to those who didn't believe in religion, and even though it was not a particularly Christian prayer. Well, the court, much to the disdain of us Christians, they said, yeah, that is unjust. It is a violation of the separation of church and state. And so God has no place in a public school anymore, is in effect what they affirmed. And so the First Amendment continues to be incorporated against the states using the 14th Amendment, and the states no longer have the ability to allow prayer and religion to be promoted in public schools. Some of you may be wondering, why do I have this picture of Linus from the Charlie Brown Christmas special? Well, there's a reason for this. So, the Charlie Brown Christmas special, this was something that came out in something like 1963, 1964, and it was made precisely because the authors of Charlie Brown were very concerned about decisions like Ingle versus Vitale. So put yourself in the shoes of people at that time, devoted Christians, and you you would have been worried about the secularist trend of the times. And so the authors of the Charlie Brown comic book and the people who made that Christmas special, they said, look at what the Supreme Court's done. They've basically written Christianity, written God out of our public institutions. And so the guy who made the Charlie Brown Christmas special, he said, well, if the public schools aren't going to promote the real meaning of Christmas, then we ought to. And so when the Charlie Brown Christmas special was made, the decision was made very early on to have Linus give a speech about the real meaning of Christmas and why it was intimately connected with the birth of Jesus Christ and the nativity story of the Bible. And so this famous image from pop culture, from a revered American symbol, Charlie Brown, this image of Linus giving the nativity story speech, that's from the aftermath of the Engelbrecht-Vital case, as Christians around the country worried about what was happening to the public respect for Christianity. So I like that attitude that he had. If the public schools aren't going to protect Christianity and defend it, well, maybe we ought to step up and do whatever we can to make sure people know the real meaning of Christmas. So one important aftermath of this decision has been the increasing sort of exodus of Christians from public schools over the years, as this case has continued to reverberate throughout history. We've seen that secularism in public schools has sometimes just given way to a pretty active anti-Christian set of principles in education. Sometimes schools not only don't teach Christianity or regard it as neutral, but more often the schools simply use their secular veneer to push beliefs down the children's throats that are frankly anti-Christian. So when schools pass out condoms and promote sex before marriage and things like that, this is an example of the kind of thing that public school secularism has done. And so many Christians have saw fit to go into private schools and homeschools, which is perfectly understandable. But in effect, what has happened is public schools have become more and more entrenched in their anti-Christianity, and private schools have been, more separated from them. And so public schools no longer really reflect a sort of broad consensus of the American people as they once did. So let's talk about Miranda. I apologize that this is a longer lecture than usual, but we should be wrapping up here soon. I'll try to go on no longer than, no more than another half hour. So if you want to take a break and finish tomorrow, you're welcome to do that. But these are very important cases that we've got to understand. In my intro class, I normally split this topic up into 2 days rather than one. So I want to talk now about a very different case that also involves civil liberties, the Miranda case. So this one is very different because the topic does not really relate to school prayer or religious freedom. Rather, this is one of the many Supreme Court cases in the 1960s that related to criminal justice and the fundamental liberties that should be enjoyed by accused criminals. So the Miranda case is very famous, and yet we often don't know what that case was actually about, even though we know we often know the outcome of the case, and his name is very famous as the progenitor of the Miranda rights doctrine. So let's back up and understand just what the case was. So this was a case that involved a criminal whose name was Ernesto Miranda. Miranda had raped and kidnapped a young woman, and he was interrogated by the police. He confessed to the crime shortly after. So make no mistake here. He is asked by the police, did you rape and kidnap this woman? And he confessed to it. And so this could be seen as an open shut case where, oh yeah, he's guilty, throw the book at him. But the ruling is later appealed to Arizona's state Supreme Court. And Miranda ends up getting some calculated lawyers, or some calculating and conniving lawyers, who come up with an argument to throw out Miranda's conviction. And their argument is that the Fifth Amendment, which bans involuntary confessions, so basically confessions that are tortured out of you. So the Fifth Amendment was understood by the founding generation in a pretty clear way. If the cops are beating you up to get you to confess, or if the cops are saying that you better confess or we're going to make sure that the court holds you in contempt of court. These kinds of things were understood as clear Fifth Amendment violations. And, of course, again, just this is repetitive, but the Fifth Amendment was initially seen as a restriction on the federal government, not on the state governments. But put all of these facts aside. And the Miranda lawyers, they said, oh, well, was it torture? Or they argued it was torture for Miranda to simply not know that he didn't have to confess. So just again, so this is so astonishing, I have to say it again. So Miranda's lawyers didn't make the argument that Miranda was tortured, right? They didn't make the argument that the cops beat him up or that they tried to basically get him to confess by holding him in contempt, because they couldn't do that. The cops didn't do that. No, Miranda's lawyers argued that it was torture for Miranda to simply not know that he didn't have to confess when he was asked. So the Supreme Court has to decide. Is it torture if the police just don't let the guy know that, oh yeah, you don't have to confess if you don't want to? So the police are accused of just not saying something that to most ordinary people is obvious, right? You know, if you are being asked by the police whether you did something, it should be obvious to any serious person that you don't have to confess just because they ask you to. Well, not to the Supreme Court of the 1960s. The Supreme Court said in response to the question, is this torture? They said, of course it's torture. The Supreme Court said, yeah, it's torture because he didn't know that he didn't have to confess. And so this guy who, again, was a rapist and a kidnapper, his conviction was thrown out. It was declared to be a mistrial. And so the Supreme Court, in effect, seemed to just want to let a criminal, a rapist, roam the streets and this kind of thing. Now, justice is ultimately done because Miranda is later... so he was not found guilty, or sorry, he was not found innocent in one trial and then found guilty in another trial. That would have been what's known as double jeopardy, which is illegal under the Constitution. No, so that didn't happen. What happened was his first conviction was declared to be a mistrial because the confession was gotten out of him through torture, supposedly, right? Because they didn't tell him that he didn't have to confess if he didn't want to. And so anyway, justice is eventually done because even though it was declared to be a mistrial, it has to go to trial again. And the prosecutors simply try to convict him on evidence that isn't the confession, and they succeed because the guy was as guilty as they come. And so you could say that justice is done despite the Supreme Court and not because of it. And so this is why we have the famous Miranda rights, where whenever you watch the movie Cops, and you see similarly unsavory-looking fellows like this Miranda, who are guilty of crimes, you always see the cops say, you have the right to remain silent, and then the other Miranda rights. This is all because of the Miranda case. And so one other thing that it did that's important is that it was the first case to incorporate the Fifth Amendment against the states. So in addition to defining the Fifth Amendment ban on torture in this very, very loose way, where all kinds of things seem to be torture that aren't torture, It also nationalizes criminal justice policy and gives a command to all the police around the nation to have these certain procedures. And so this case is controversial not only because of the looseness by which it considered this question of torture, but also because it sees from the states, as most incorporation cases do, their right to figure these issues out for themselves. And so another important case from this time that I can't spend quite as much time on is the Mapp, Ohio case. This is important because it is the foundation of the exclusionary rule. It's the case that incorporates the Fourth Amendment against the states. So much like the Miranda case incorporates the Fifth, Mapp versus Ohio incorporates the Fourth Amendment, which prohibits unreasonable searches and seizures. And so what was the Mapp case? Well, the Mapp, Ohio case was a case where the police broke in to there was a person, this Joanne Mapp in Ohio, and she was suspected of harboring violent terrorists. And when the police went into her home, they had a warrant, they had a kind of warrant for the terrorism, if I remember correctly, that was dubious. Like, it was a warrant that was kind of perfunctory and not but the police believed they had some legal cause to be there to search for violent terrorists. Well, the police find in her home illegal child pornography. So no terrorists are there, but they do find illegal child porn. And this causes a question for the Supreme Court because there's no question that Mapp was guilty of possessing illegal child porn. I mean, it was found in her basement or closet or something like that. So there's no question of her guilt, but that wasn't why the police were even there. So can you actually use this child porn as evidence against her? And so this was the question. Well, the court said, no, you can't, because if you have unlawfully obtained evidence, then that evidence cannot be used against you at a trial. So this is the exclusionary rule. This is what says that police can't use any evidence against you that's obtained illegally. And it's what establishes that the Fourth Amendment applies not only against the federal government, but against the states. So the basic trend of these criminal justice cases at the time was to, in some ways, many Americans who condemned these cases, they looked at them and said, well, at every turn, the Supreme Court seems to be making life easier for criminals and harder for police, right? So law enforcement is getting the short end of the stick here. And if you're a rapist or a criminal or someone who owns child porn, well, the court is perfectly happy to make it easier for you, right? And so many Americans at the time were worried about this and wondered if America was becoming more and more lawless because of these Supreme Court decisions. And so that's why these two are very important. So I'm going to hopefully breeze through these last two cases, Roe versus Wade, and then the Brown Board of Education decision. So the Roe versus Wade case is very fascinating because it is of great recent impact in American politics, as we've seen the lingering controversy surrounding Dobbs versus Jackson Women's Health Organization, where Roe versus Wade is overturned. And so the legitimacy of the Roe case is a very contemporary issue today. And the Roe case, I think, helps us to better try to come to a deeper understanding of the role of the court in our system. So as hard as it is for you to do this as Christian people, I'm going to ask you to try to do something. I want you to try to consider this Roe case without thinking or dwelling on the question of whether abortion is immoral or whether it's moral. So whether you're a hardcore pro-choicer that thinks this is the individual woman's prerogative to be able to make her own decisions, or whether you're a pro-life Christian who thinks abortion is genocide. I want us to not think of abortion simply according to the morality of the action, right? I think so often we base our evaluation of the Roe decision on whether we agree with the morality of abortion or not. But actually the case is worth considering in terms of its legal and constitutional reasoning. And even people who advocate strongly for abortion rights, such as famously Ruth Bader Ginsburg, they were very disturbed by the kind of poor reasoning of the Roe case. So I want us to try to abstract a little bit from the morality of abortion taken in itself, and try to understand the legal issues that are at play in this case. So the heart of the legal issue here is over this question of whether or not the court can enforce rights against the states that are not in the Constitution. So as you've seen from throughout this lecture, I'm pretty skeptical of the incorporation doctrine through and through. And I'm especially skeptical of its use by the modern court to shut down the states from doing things that the judges just say they don't like very much. But with all that said, you can at least argue, as a reasonable person, you can at least argue that in cases like Miranda or Engel versus Vitale, the court is actually incorporating a right that is in the Bill of Rights. So, yeah, I mean, the court is, I think, using those amendments very loosely. But nonetheless, there's no question that in the First Amendment, there's a religious establishment clause. And there's no question that in the Fifth Amendment, you have a ban on confessions that are coerced out of you. And the court possibly applied those things wrongly. But the words are there. Roe is different because in Roe, and also in the case that preceded it, Griswold versus Connecticut, the court is actually enforcing rights against the states that it basically is making up. So these are not rights that are being sort of loosely interpreted as applicable because of this or that amendment. No, these are basically just rights that the court thinks are good, and so they're going to import it into the 14th Amendment. A good example of this is in the Griswold case, which is basically that is basically the case that is responsible for the Roe case by way of its legal reasoning. So Griswold versus Connecticut was a case that was about contraception. And it was a case that affirmed that the states could not restrict access to contraception. And what's important here is the legal reasoning of the court. The court declared that you can't restrict contraception because there's a fundamental right to privacy. And the problem for Justice William Douglas, whenever he declared that there's a right to privacy, is that that right to privacy is not actually in the Bill of Rights. At best, you can only infer it from something like the Fourth Amendment, which is about criminal justice and which is about unreasonable search and seizure, so it's not at all about contraception. Or maybe you can sort of say the Ninth Amendment, which ensures that not all rights are listed, and so there are some unlisted rights. Maybe that falls there. But even the Ninth Amendment, you run into the problem of, well, that was meant to empower the states against the federal government. So no matter which way you look, the right to privacy can't really be justified by the text of the Bill of Rights, and certainly not a right to get contraception. And so what did Douglas say, Justice William Douglas? Well, he said, sure, the right to privacy is not in the Constitution's text, but he argued that it flowed from the penumbras and emanations of the Constitution. Now, you may need to forgive me because I think I need a fortune teller or some mystic to help explain what he means by that here. Because it seems to just be pulling words, out of nowhere to sort of justify a policy he likes. So, yeah, the right to privacy, it's not in the Constitution, but it flows from the penumbras and emanations of the Constitution. So basically, I think it should be a right, so we're going to read it into the Constitution with no real justification. And so this is the basis of the Roe decision. So Roe is not about contraception necessarily, but what the judges did who decided in the Roe case was they took this right to privacy that had been established in the Griswold case, and they used it to say that if you restrict abortion, if you're a state government and you impose some restrictions on the practice of abortion, then you are imposing a undue burden on a woman's right to privacy, and you're violating her right to an abortion. So this basically attached to that right to privacy the addendum that abortion is a fundamental right under the Constitution. Now, when this decision was laid down in 1973, I want us to put this in context. 1973, this decision, it overturned abortion law in 47 states. So it's not like the court was on the side of popular opinion at this time. Rather, the court overturned the democratically passed laws in 47 of our states to impose abortion rights on the nation. And because Roe has stood until 2022, so 50 years of the Roe case, and its effects on the American psyche, I would argue that it's fundamentally twisted the way most Americans actually understand their Constitution. Most Americans today seem to think that as long as the judges give us policies we like, they're doing a good job. But that's not representative government. That's not constitutional government. When the Supreme Court asks us to affirm rights that it makes up, and that are not in the Constitution, so they were never established by a process of the consent of the governed. It's asking us to reject the very idea of constitutional government and to embrace government by the judiciary. The Constitution is supposed to belong to we, the American people, right? That's the first three words. But when the court has this exclusive prerogative that it has invented for itself to determine what our rights are and how they ought to be protected, the court has essentially become the author and architect of its own powers, and any restrictions on federal power basically have disappeared. And so Roe has certainly thrown into doubt, or for the years that it stood, it threw into doubt the moral credibility of our institutions, because it liberalized a policy that huge swaths of Americans believed was genocidal and wicked. But even when you abstract from the moral consideration about abortion and consider it simply at the level of law and constitutionalism, Roe versus Wade was so problematic because it was a challenge to the very idea of constitutional government. It's a great piece of evidence for the idea that judicial activism often fails to settle debates, which is the intention. They want to just settle a debate by declaring that this is a constitutional right, so shut up about it and get on board with it. So judicial activism fails to really settle debates, but it instead just intensifies them. Think of how for 50 years Americans have had to scream at each other about abortion because this is a national issue because of the Roe decision and what it did, and how it declared that the Constitution simply protects a constitutional right to abortion that is nowhere in the text of the document. So there's some irony here, because when the citizens who were pro-choice, when they were protesting against the Dobbs decision a few years ago, they were ultimately protesting against democracy, right? So think about how funny that is. These are the same people who believe they are in favor of democracy, and they often condemn things that they say are undemocratic. But what are they protesting? They're protesting the fact that the Supreme Court has said it doesn't have the right to settle this debate for the American people, and that this is an issue that belongs to the elected representatives of the people in the different states to decide. And so when the people were protesting against the Dobbs decision, they were literally protesting against their democratic right to make decisions about abortion for themselves. They were protesting against self-government and states' rights and representative principles. And so this is a great example of the crisis in our institutions today. We have citizens who basically reject representative democracy and constitutional government. They think that the ends justify the means. And they think that even if it's unconstitutional for a judge to settle abortion policy in favor of the pro-choice cause, they want to see it done because it's good policy for them. And they don't trust the American people to settle it for themselves within their states. Because sure, California and Massachusetts, they might have really, really left-wing pro-choice policies, but there's going to be all these red states that impose restrictions, and we can't have that. We can't have citizens in conservative areas have conservative legislation. And so, as happy as I am personally, the Roe decision was overturned, not only on moral grounds, but even more so on the legal grounds. I believe that the battle for judicial responsibility has only begun. It is not concluded. We still have a lot of work to do to recover a real understanding of what our Constitution is all about. So civil rights. This is the one I want to spend the least amount of time on because, of course, this lecture has already been very long, and this is one that I believe you all know pretty well already, certainly. So I'm going to say just a little bit about Plessy and the Brown Board decision. So the Plessy versus Ferguson case of 1896. This was the case that said segregation was constitutional, but it had to involve facilities having relatively equal accommodations for both races. So separate but equal was the rule it established for interpreting the 14th Amendment. One problem, of course, with this was that usually the provisions were not equal, and yet the court didn't intervene. So Justice John Marshall Harlan, in a famous dissent in the Plessy case, so he did not agree with the decision. He was the lone dissenter. There was only one guy who opposed Plessy on the court at the time, and it was him. He famously said, "Our Constitution is colorblind." He said, no, we can't do this because that flies in the face of the real intent of the 14th Amendment, which was to make sure that whether you were white or black, as long as you were a citizen, the equality under the law applied equally to you. And so that was an eloquent dissent that had a firm basis in constitutional principles. So this issue obviously is not settled by the Plessy case. So it goes to the Supreme Court again much later in the 1950s when the civil rights movement is making more and more inroads in American politics, and the court has to reconsider the issue of segregation. In the Brown versus Board of Education of Topeka, Kansas decision, the court said that racial segregation in public schools is unconstitutional. And while the ruling of the decision is rarely questioned by people on either side of the aisle, liberal or conservative, the reasoning of the court is sometimes criticized because the court did not rely on John Marshall Harlan's dissent and his argument that the Constitution through the 14th Amendment was meant to be a colorblind document. No, the same court that decided on Brown Board of Education, they later upheld affirmative action, which is the furthest thing from a colorblind constitution. So the court arrived at this anti-segregation decision not because it relied on really the clear text of the Equal Protection Clause or a kind of concrete constitutional argument against segregation, which I believe could have been made, but rather the Supreme Court said segregation ought to be unconstitutional because we have looked at studies from social science, from psychologists, from leading experts of our day, and they have made it clear that black students tend to have self-esteem issues if they go to black schools and don't feel equal with whites. And so consider that. The Supreme Court is making a decision that's supposed to be a legal decision based on sociology and social science and psychology, things that are kind of outside of the law. And so this case's reasoning was quite controversial. Of course, there were some racists who simply opposed the decision because they really wanted segregation to be protected. I don't want to deny that those people existed. But there were also very serious people who were worried about the precedent in the Brown board decision. They were worried that this seemed to open the door for judges to basically revolutionize law and policy by relying on statistics and data and things that had nothing to do with the Constitution, right? And so was Brown versus Board of Education really the first step in the process that led to Roe versus Wade, where the court asserted more authority for itself to settle these controversial issues? So that's one important outcome of the Brown versus Board case. It would have been better, I think, if they would have just affirmed the John Marshall Harlan dissent and ruled out this process of racial discrimination by law on the grounds that our Constitution is colorblind. That would have, by extension, ruled out affirmative action later. But the court didn't do that, really. They relied on kind of more shoddy forms of reasoning that were sort of separated from the rule of law. And in many respects, that was responsible for much of the legitimacy crisis of the court in the aftermath of that decision. So as you know, the Brown versus Board of Education decision was fiercely protested by people around the country, and especially in the South. And while it is true that a lot of these people simply harbored racist views, a lot of the resistance to the decision was also based on the fact that it was seen as a kind of lawless usurpation by the court, where they seemed to have no concern for the rule of law, and they were simply trying to dictate policy to the nation with a view to whatever they thought was good at the time. And so this is, again, something that helps us consider the question of how serious we are about a limited judiciary. Do we want to be people that like judicial activism as long as it gives us the stuff we like? Or do we want to have a consistent set of constitutional principles that seems to arrive fairly at whatever policy it arrives at without a view to whether the judge thinks that this or that is moral? So thank you all for having listened to this lengthy lecture. I do apologize for the length, but it was, just full of a lot of important meat that we had to get to. And just a couple concluding thoughts. This won't take more than a minute. So questions about judicial activism and about civil liberties are likely to persist because they really strike at the heart of what it means to live in a republic. In America, we're a people that values liberty. We believe that this is the land of the free and the home of the brave. But we also understand that there have to be some limits on individual liberty at times. We believe in the need for order and for stability in the rule of law. So just because you have free speech, for example, does not mean that you can publish something in a newspaper about your neighbor that is patently untrue, right? You can't say your neighbor was convicted of murder, even though he wasn't, because then you'd be guilty of defamation, right? And so there have to be some limits in a republic on individual liberties. And so we have sometimes struggled to balance these competing values of order and liberty. And the court has tried, I think, sometimes in a precarious way, to maximize individual liberties even at the expense of ordered liberty and of the constitutional rights of both the Congress and, more recently, of the state governments. And so the Bill of Rights has been expanded. And incorporation is unlikely to disappear because most Americans of both parties like incorporation, right? The conservatives, for their part, they like to incorporate things like the Second Amendment, and they often talk about free speech. And so there's kind of broad appreciation for incorporation, and yet it still poses a central problem, I think, for our republic, which is that I think that in the rush to simply make the Constitution about a list of rights at the end of the document that wasn't created by the original Constitutional Convention, I think maybe we've lost sight of what the purpose of the Constitution was. The Constitution was meant to establish a form of government that would reconcile liberty and order, that would create a set of institutions that would balance power in such a way that unchecked government would be restricted. It was the intention of the framers when they met in Philadelphia not to decide what the people could or could not do, but instead to decide what the government could do and could not do. And I think this focus on rights that has been the natural outcome of incorporation and of modern civil liberties doctrines, it has been valuable in many respects, as we've seen the increasing expansion of individual liberty against the government. But it has, I think, maybe unmoored us too much from the idea that the purpose of a constitution is to create a limited government and to leave the people free to make their own decisions within the constitutional authorities of the states and the Congress. And instead, the Bill of Rights has been used as a way for an activist judiciary to settle policy debates in ways that it thinks are appropriate. And so hopefully this lecture was helpful, and I do look forward to talking to you and seeing you again next week. Thank you. Bye-bye.